Okay, welcome back to the fourth session of the Long Arm of the Law. Those of you who have been here in previous years know that our guest star has been Kenny Rogers. However, he's been very busy with the Country Western Awards in Nashville and could not join us today, but he has sent a substitute, namely Bobby Fuller. Let's see if Now, this is no mean feat because, as some of you know, Bobby Fuller died in mysterious circumstances in 1966, I believe. And so to have him with us with his group is really an amazing kind of Charleston achievement that only Katina could pull off. So they are going to sing to you. They're going to sing I Fought the Law to get us in the spirit of this session. This is I Fought the Law in Latin, okay? Except, we're not getting the here.
I fought the law and the law won. I fought the law and the law won. I left my baby and it feels so bad. I guess my race is done. Well, she's the best girl I've ever had. Her robbing people with a six-gun. I fought the law and the law won. I fought the law and the law won.
Thank you. Thank you. I actually had a moment, when I thought maybe we could get Katina to get some of the Charleston librarians dancing on the stage to this, but, I wasn't sure how well that would go over. Anyway, so our speakers in succession are as follows, and they are going to do their thing in order, needing no introduction beyond what you already have in your program. So first of all, Bill Hannay, whoops. Well, Bill decided not to come to Charleston this year. He decided on the weekend that instead he would go to a hospital in Chicago and spend the time there getting operated on. So he sent this image and he sends you his greetings. But standing in for Bill, we have Bruce Strauch of Charleston fame. He's a professor at the Citadel. He's an attorney. And sometimes he even looks a little bit like Bill Hannay. So I think he's a very good stand-in. We then will move to Georgia Harper, who's the Scholarly Communications Advisor at the University Libraries, University of Texas. Georgia and I met many years ago. She was an attorney for system-wide copyright for the Texas system and has done some marvelous work that many of you know about. And our final speaker is Madeline Wessel, who's Associate General Counsel at the University of Virginia. And I have heard that she has done wonderful things to help the librarians with their various concerns in digital projects. So that is our lineup for today, and without further ado, let me introduce Bruce.
I am married to Katina and inter alia to the Charleston Conference, and I have a perfect attendance certificate to prove it. Some years ago, she found this incredible attorney in Chicago named Bill Hannay, who was a Yalie and a Supreme Court clerk, which just mystifies me, that level of brain power. He commutes to work by train, which I think is an indice of a big deal attorney, stand on a train platform with an overcoat and a briefcase. And he's an antitrust lawyer and a tremendously talented guy, and then he tells us he has to have heart bypass, and I was indignant. I said, Bill, this is not all about you. What about us? And he was strangely unmoved by the whole thing. And he's come through it. It really is a fairly finely tuned operation now. He's at the dreadful phase where you're sitting there, your ribs have been broken open and now stuck back together, and you have to blow into this tube with this little ball that goes up to get bad stuff out of your lungs. Do it 50 times, and you start thinking finally of a death panel. But I have his paper here, and it's not my subject. I'm not an antitrust lawyer, and so I'm going to do this dreadful thing of reading it, which my students think the most dreadful thing I can do is expect them to know something and ask them questions in class. But this is fall out of the chair boredom, but I'll try to get through it. All right, as you may recall, in April 2012, the U.S. Department of Justice filed a civil suit against Apple and 5 of the 6 largest U.S. publishers, alleging violations of the Sherman Antitrust Act from an alleged conspiracy to fix the price of e-books. They got a quick settlement against Hachette, HarperCollins, Simon & Schuster, and the others, and Apple held out. Now, how did this all begin? Amazon's Kindle e-reader, more and more publishers started offering e-books. Amazon sought to dominate the business with a low-price marketing strategy. Amazon would retail all e-books, bestsellers, at $9.99 for use on its Kindle e-reader, even if the print version sold for a lot more. Publishers were not happy about this pricing point, and neither was Apple, which had plans to include an e-reader program on its iPad. The publishers and Apple began meeting in 2009 over into 2010. They executed individual agency agreements with each of the publishers. Now, you got to pause and think about that. An agent works for someone else. That someone else has a right of control. So all these publishers were using Apple as their agent. Now, they would have other agents, perhaps, but they would set the price since the publishers had the right of control. This was called the agency model. And they also executed a thing called most favored nation clause, which is strange. I don't know why we don't have more imagination. That's a diplomatic term. Usually country A gets low tariffs, country B does too. And in the context of this agency model, if some other person than Apple got a lower price on something, Apple got to sell at that low price. But the main guts of the conspiracy was to force Amazon to cave into this agency model, for Amazon to become an agent of these 5 publishers, and then to force Amazon to raise their prices. Now, why they felt they needed a higher price is another topic, and I was just reading that it only costs $2 to produce a hardback book, so I don't understand why they needed $11 as opposed to $9.99, but that's something for their perks and way of life. All right. When the government sued, the publishers settled out, and incredibly, they settled out for $155 million. Now, in the popular book publishing line, that's an incredible hit. I don't know how they can sustain that and why they thought they were, anyhow. The most favored nation clause eliminated any risk that Apple would ever have to compete on price when selling e-books, while as a practical matter, forcing publishers to adopt the agency model across the board. The court concluded the conspiracy significantly harmed consumers. The laws of supply and demand were not suspended for e-books. When the publishers increased the price of their e-books, they sold fewer books, which is another interesting question. Let's sell fewer books at a higher price. I don't know why people always think that will work. Henry Ford Henry Ford disproved that. Judge Cote found there was compelling evidence that Apple conspired with the publisher defendants to eliminate retail price competition and raise e-book prices, and overwhelming evidence that the publisher defendants joined with each other in a horizontal price-fixing conspiracy, and they had all the phone calls from the CEOs. This was done at the highest level, and everybody panicked and caved in. Now, what to do with Apple? Because Apple resisted, so they have issued a final judgment against them. We're determining their damages. External monitor to ensure that Apple will fall into line. I guess what really startles me the most about this is that I don't particularly believe that our Justice Department is after justice. I think they're careerists and they like putting Martha Stewart in jail and things like that. And then sort of high fives all around. We got a career high, and I can move on to a private firm. Does anybody remember the Justice Department under Jimmy Carter and the IBM suit? That thing went on for over a decade until the government just finally threw up their hands because the whole terrain had changed. The personal computer had come along. IBM's dominance died. The Sherman Act, which I know next to nothing about, don't fix prices. The Sherman Act also says don't monopolize a market, don't conspire to monopolize. I really think that if they hadn't got this slam dunk, so everybody go, great, our resume looks great, they would have gone after Amazon. Because it looks to me like they were trying to dominate the whole market, and then they would have been in the same embroiled mess they would have with IBM. But that's my little thoughts, and not Bill's. Then he goes on to talk about about libraries and how they just really stick at the libraries who are lending out these books much higher because they want people to buy the book, buy the e-book. And he says that's, they're obviously after money. He doesn't see that as an antitrust matter unless they all get together and collude on the whole thing, which there's no evidence of. All right, moving on to Google. Google's doing this mass copying of books and things. And their defense is fair use, their digital library. And that suit has sort of reached a point where the Authors Guild was suing Google. And there's a question. Google says the Authors Guild doesn't really represent anybody, that they're not representative of anything, and that they shouldn't be a class, shouldn't be able to create a class action. And since everybody's waived a jury in it, so the judge said, well, look, let's look at the fair use defense first, and then we won't have to worry about, if it is fair use, we won't have to worry about whether the Authors Guild is a proper party here. So they're moving ahead on the fair use analysis, and there's another case called the Hathi Trust case, and it has to do with transforming things. And Google is relying on that to say that, well, in putting this in this giant database, it's a transformative. I've made something different, and therefore that's a fair use. And the judge says the use to which the works in the Hathi Trust digital library are put is transformative because the copies served an entirely different purpose than the original works. The purpose is superior search capabilities rather than actual access to copyrighted material. Is that sinking in? Does that sound right? That's the only reason that they're doing that? I mean, I think it's going to be the same. We're going to read the books, aren't we? I mean, it's nice that we can data mine and all that, but I think they're doing it so we can read the books. This is Bill's words. It's hard to accept the proposition of Judge Baer and perhaps of Judge Chen that the ease of electronic searching of scanned documents is legally transformative. Research for centuries has been done by human beings reviewing the text of books and documents, looking for words or names or ideas. The fact that a computer can perform that search process faster does not, it seems to me, transform the process into something so different as to allow an unauthorized party to ignore the copyrights of the original authors and publishers. Copying millions of books and storing them in a searchable database may indeed be a useful thing for the world, but defending that copying on the ground that is for the public good strikes me as little more than a Robin Hood defense in which stealing from rich authors is justified on the grounds that the proceeds are given to poor academics. And he doesn't see that as a fair use. Now, the most disappointing thing about being here is that Bill was a spizwink at Yale, which is the great singing group, and he thinks nothing about standing up in front of a group like this and just singing a cappella. And at the end, he would always take some popular song and put some lyrics in there about Google or Apple or something, and everybody would sing along. And it just sort of brought down the house. I'm going to end with a sickly smile, and I'll turn it over to the next speaker.
Transform. Well, I'm going to talk about transformative use. I'm not going to talk about Google, though, because that case hasn't really been decided yet. But we had a bunch of really super cases this year that do go into why we think things are transformative or how we can be sure they are. And in academia, that really matters to us. This trend with transformative use started in 1994 with a case that was a parody that Bill might have enjoyed standing up here and singing about. It was the Oh Pretty Woman case. I don't know if you're familiar with it, but it was a song by Roy Orbison that was parodied by a rap group and turned into a song about an Oh Hairy Woman, a prostitute walking down the street. So they did quite a number on Roy's song. The Supreme Court did a number on the people who sued, however, by saying that what the rap group did was transformative. They didn't elaborate different types of transformative fair use, but the court decisions since 1994 are a lot easier to understand if we recognize that there are different types. Now, Pam Samuelson described an approach that I found really useful in an article from 2006 and 2009 called Unbundling Fair Use. It's important to understand, first of all, that these transformative uses are most likely to be fair use when they support free speech, First Amendment values. Second, one might create transformative works, and one might also have transformative purposes in using another's work. And third, the three categories that Samuelson identifies within works and purposes can overlap. Transformative works are the easiest to recognize. They're the parodies, the satires, the appropriation art. These photos show how Jeff Koons adapted an advertisement for selling shoes into a collage that he calls Niagara. The court found that use to be transformative when, as here, the work is used as raw materials in furtherance of distinct, creative, or communicative objectives. The use is transformative. Transformative purposes include productive uses and orthogonal uses. Now, HathiTrust, to whom Bruce referred, is a good example. But first, let me give you some ones that are more familiar, perhaps. These would be uses that promote ongoing authorship. Research uses, including making copies that will be used to inform a critique or a commentary. Copies for news reporting. Quotes to illustrate a point, to demonstrate, to explain. Another example might be making a photograph of a sculpture for an analytical piece. HathiTrust comes into the picture here with transformative uses, where its digital copies of books are used to enable access by the blind and visually impaired. Now again, one might wonder, as Bill did, what's so transformative about making books available for the blind? But that's what we have these days, is a court decision that says it is. It's up on appeal, and we won't know for sure how it's going to come out. It's something to watch, but it's certainly something that a lot of people are cheering. Orthogonal uses are those wholly unrelated to the use made or envisaged by the original author. These are uses for a new audience, for a new purpose. And HathiTrust is again instructive on this point, the point that Bruce raised. Digitizing works to index them for full text search and to enable text mining are the examples we have today. Now again, these are strongest when they support First Amendment values. Let me give you another example to illustrate the differences among these categories. One might critique or comment upon Margaret Mitchell's book, Gone with the Wind, by making a new creative transformative work, another novel like The Wind Done Gone, or by writing a scholarly article. Both might be fair uses, but one would rely more on a transformative work, creating a new work, the other on a transformative purpose, a productive use. One might also use her work for an orthogonal purpose by including it in a text mining project, perhaps to discover new information about authors of her era or her genre, which information itself might become the subject of another study. Now, my use of these images is also orthogonal. I use them to provide a visual reference for what many would say are rather subtle nuances that define different aspects of transformative fair use. As an instructor, I like to rely on fair use of visual images to promote understanding of the law among those who want to keep their activities within its sometimes evanescent boundaries. Now, keep in mind that even if a use or a purpose is transformative, the user still must comply with the rest of the requirements for fair use. She must use only so much of the other's work as she needs to achieve her transformative work or purpose, and the benefit of the use to the public must exceed the harm to the copyright owner's normal expectation of commercial exploitation of his work. So with this framework in mind, let's look at what happened in 2013. I chose 3 cases from what was a rich array of results this year with very interesting challenges. First, Ed Sullivan challenged the Jersey Boys, Faulkner challenged Midnight in Paris, and street artist Derek Seltzer challenged rock band Green Day. First, we'll do Ed Sullivan. SOFA Entertainment is the owner of the copyrights to the Ed Sullivan Show. They sued Dodger Productions, the producers of a play about the 60s rock band, The Four Seasons. Dodger used a 7-second clip of Ed Sullivan introducing the band. In the view of the Ninth Circuit, the use was for historical significance. The court noted that the defendants had imbued the clip with new meaning and had done so without usurping whatever demand there was for the original clip. The lower court awarded Dodger's attorney's fees of $155,000 because it viewed SOFA's infringement claim as objectively unreasonable and determined that awarding the fees would deter future lawsuits that might chill the creative endeavors of others. The Ninth Circuit affirmed that award of attorney's fees at the same time that it affirmed the fair use defense. Now, this exemplifies a productive purpose. The Jersey Boys uses a 7-second clip to show, to illustrate, to demonstrate a point in the boys' historical trajectory. Making it on the Ed Sullivan Show was a major accomplishment. In fact, at the time, the Four Seasons viewed it as their best hope for reviving their popularity in the midst of the British invasion. The clip also illustrates an orthogonal use. The new audience, the different expressive purpose, the recontextualizing, all of these give the older content new meaning. The use of this image serves as a visual referent for me to aid you in understanding and retaining the information that this case embodies, the information I'm trying to convey. These actors and their director and producers are taking a risk, and they're making a statement about their right to reference the culture of the 20th century, our culture, for purposes other than the original expressive purpose of the creator of the materials, and for a different audience. And that's what I'm trying to do as well. Now, Faulkner. Has anyone seen this movie? All right, I figured so. Midnight in Paris, Owen Wilson's character, Gil Pender, at one point says, the past is not dead. Actually, it's not even past, which he attributes to Faulkner, even though it's slightly off. And he goes on to recount a conversation he's just had with the long-dead Faulkner as proof of his assertion. Now, this movie is a comedy. It is filled with literary and artistic allusion. This particular quote describes Pender's problem. It's golden age thinking, the erroneous notion that a different time period is better than the one one's living in. You know, it's a flaw in the romantic imagination of those people who find it difficult to cope with the present. This golden age thinking pervades the film, both in its plot and its theme. Now, Faulkner's point was altogether different. It was about the past catching up with you. And this suggests that the use is orthogonal. It's a productive use as well. In other words, Midnight's director had a transformative purpose. The quote is used to illustrate a point about our attachment to the life of the past, to explain, and this is, as you all know, a rather traditional use of a quote, a short quote. The court elaborates on the orthogonal purpose, however, by going on to say the speaker, time, place, and purpose of the quote in these two works are diametrically dissimilar. And the quote even takes on an aspect of transformative use in the creative sense, in the court's view, and this is where they quote back to the Oh Pretty Woman case, Campbell. The use of these 9 words in Midnight undoubtedly adds something new, with a further purpose or different character, altering the first with new expression, meaning, or message. So the quote has been entirely recontextualized, and that itself is what's transformative. Now, the third case relies on a creative use, not the purpose we've been talking about so far. Seltzer v. Green Day. So photographer Richard Staub had earlier taken a photograph of a wall that was just plastered with Derek Seltzer's street art. And when he was later hired by Green Day to create a video for the group that would play during a live performance, he built a set that included an image that was inspired by Seltzer's work. The video actually filmed a series of artists coming onto the set, adding art to the wall, and then exiting. So the film was the creation of the wall. Finally, the video played as the backdrop for a single song in a Green Day performance. And these 3 photographs illustrate the process of that transformation. Now, interestingly, in this case, the plaintiff actually helped the defendant make his case. Seltzer complained about how much Green Day had changed his work, how horribly they had deformed it, and how they had changed its meaning to be almost the opposite of what he had intended. Well, of course, these qualities are precisely what made it transformative and a fair use, even though Green Day used the whole of his image. Further, it was clear that Seltzer would never have given permission for this, so Green Day had no option but to rely on fair use. And importantly, the use supports a free speech value. And finally, the harm to Seltzer was, by his own admission, minimal, in that he never would have licensed the work. So the value to the public far outweighed the harm to Seltzer. So what does this mean for us in academe? Well, of course, being from academe myself, I see very positive implications for scholars, but also for their publishers, for artists and their distributors, for actors, poets, their directors, and their producers, and of course for instructors. These cases are very good news for all of us who are involved in the creation, dissemination, and discussion of works. They give us all room to move, and this is what fair use is supposed to do. As the court in the Jersey Boys case said, it was quoting an earlier fair use decision, an overzealous monopolist can use his copyright to stamp out the very creativity that the act seeks to ignite. To avoid that perverse result, Congress codified the doctrine of fair use. So fair use requires of us as copyright owners that we not hold so tightly to our views about what we can or should control. Copyright is porous on purpose. The law gives us all these freedoms, and our society is a lot better off when creators are not afraid to take full advantage of them.
Good morning. I'm here as a practicing attorney at a fairly large research university, and Anne had emphasized the importance of this session being at least a little bit provocative and tackling issues of sort of current relevance. So I thought I would take us away from cases in the last portion of the talk this morning and actually talk about some hands-on issues with respect to online ed, MOOCs, and, however, some threads that I see emerging in that space in my own work for my institution and talking with colleagues at others around issues that really aren't about copyright, but I think are very important to librarians, issues like privacy and issues around data use and data rights. So here we go. I will spend about 5 to 10 minutes talking about some of the intrinsic copyright issues and concerns and IP ownership issues with respect to massively open online courses, and then you'll see we're going to move into some related spaces. So when we're talking about MOOCs or online materials, there are a number of sort of big overwhelming topics. One is, of course, course production and copyright issues, and I think some of you attended the a long session at this conference that Kevin Smith put on around copyright issues in MOOCs, which I'm sure was really wonderful. There are intellectual property and ownership rights as between faculty and institutions. And this is a topic that's heating up quite a bit right now. You've got the AAUP, the faculty organization, putting out a bit of a sort of call to arms around academic freedom rights and ownership of faculty and course materials, which they see threatened by the advent of university-sponsored agreements for massively open courses. We've got FERPA and ADA compliance, which I do want to talk a little bit about today. We've got EULAs and privacy policies inherent in participation in open online courses. And we've got some issues that I really want to close with today, which is just because it's free doesn't mean it's actually free. What's happening around data mining and data usage in this new space? And then finally, just the issue of compelled transfer of IP. And when I say compelled transfer, I mean compelled transfer of our faculty and students when they engage with cloud services around learning and teaching. It goes without saying that course materials are heterogeneous, and as someone who staffed my institution's project with Coursera, this really was brought home to me, because my thought was, well, we're going to have to get a release from the talking head up front who's getting filmed for that course, right? When you start to really think about what's involved in a course presentation, especially one that's going to succeed online, you're talking about a lot of other materials, all the fun little gimmicks. So, by the way, this talk today has been denuded of all the fun slides that I rip off the web like everyone else does to make people wake up and to say, hello, how about this point? Because unlike what Georgia did, I'm not making images the subject of this talk. Like many, many faculty, when I give a talk in a classroom or face-to-face that isn't being recorded, I use images to have fun. And faculty are used to doing those kinds of things in their teaching, and they're not used to thinking about rights concerns at all in that process. But those kinds of issues get very live and vivid. And then, of course, there's issues around delivery of materials to students or to participants in these open courses. All of these are different threads in the copyright equation. All of them really explode the safety of the traditional classroom and face-to-face teaching, which, as librarians and others involved in the teaching and learning enterprise, you know we have a lot of liberty that comes from the copyright statute, and a lot of liberty that comes from the realities of fair use in the classroom. But when you're interacting with a MOOC platform provider, they're going to treat you as an institution, if you're an institutional participant, you're having to take the role of warranting rights vis-a-vis a publisher. So we're now producing courses in an online environment where all of the conventional permissions and rights issues that publishers apply to our faculty when they publish books, or a film studio is going to apply when it's releasing a movie, really come into play in that same kind of way. And this is a sort of mental dynamic that I've found. Georgia and I were talking last night. Faculty who create these courses are not thinking about these issues. So the enterprise of trying to work with them and to have an institutional delivery of a MOOC course that is at least to some reasonable extent not totally illegal has been something that has really been challenging for us. Here's the traditional copyright exceptions that we love, that we use all the time in institutions of higher education. And they're built to support a pretty progressive and opportunity-rich teaching and learning enterprise. And the issue is that most of them, at least within the structure of the statute, are not written in terms of massively open online courses that are just generally available on the web. They're written in terms of specific hierarchies and structures within higher ed itself. And so what we're finding in this space is that fair use, again, is really, really important. And fair use has a place within the copyright advisory space for MOOCs. But what are the rules? And these are questions that I think really haven't quite been answered yet. So, for example, what are the rules when it comes to delivering these recorded course materials to thousands of individuals worldwide? Does it matter if the platform provider is explicitly for profit? We all know that we've seen the Supreme Court reject an analysis going back at least as far as Campbell versus Acuff Rose Music, the Two Live Crew Roy Orbison case that Georgia mentioned. The fact that there may be a profitable interest, motive, or result does not disallow fair use. That's a sort of old argument that was hurled at artists and others under the fair use test, and the Supreme Court said, that's not dispositive. I mean, it can be a factor, but it's not just because you're going to make money. If your use is truly transformative, you may still have a perfectly valid fair use case. But how does that concept apply in this particular environment? If you're posting courses on a platform provider who's not for-profit, and where, in fact, as I think we're all reading practically every day in the Chronicle of Higher Education or the New York Times, institutions are really looking for ways to obtain revenue from these programs long-term. So how does that affect the fair use analysis? Does our not-for-profit status help to outweigh the for-profit status of the platform provider? Does it matter, hey folks, does it matter if the content's being beamed to countries all around the world who don't have any fair use concept in their copyright regime? These are lots and lots of issues, and as one of my children said coming home from school one day, Mom, I'm perplexed by the 157 questions for which God has no answers. And, these are on that list too. He always was a smart kid. So third-party content, here's some pivots I'd say that I feel fairly strongly about, and I think, lots of my colleagues within the academy are centering our advising on, which is obviously third-party content that's integrated into, and it doesn't have to be a massively open online course, online courses, videos, content that's uploaded for broad public access. It's obviously going to work better if it's transformative, and Georgia has just demonstrated a number of very recent cases where courts are really agreeing with that. It's always important to remember the good, wonderful Ninth Circuit cases around the use of technology being our friend. So where it's possible to use content in a way that is not rivalrous with perfectly legitimate needs of content owners, that's a good way to go. If you can use thumbnails or low-resolution images, that's great. Links that are going to support a publisher's opportunity when you're using tiny bits of content can also be a helpful way to at least make content owners our friend and potentially also help with a fair use analysis. So I would say, though, that it's not viable, in my opinion at least, to say I'm going to upload a whole lot of book chapters so 100,000 students worldwide can read chapters of books. I think that's a licensing issue. People have got to tackle that one. IP ownership, just for a minute or two. This is an issue that I have found perplexing in its public parlance or discussion recently, because the reality is that this all boils down to the Copyright Act and institutional policy. And for those of you who are at educational institutions in the room, which I suspect are quite a few people, institutional policies around faculty ownership of intellectual property almost invariably distinguish between types of faculty output. I'd say all institutions at this point, except a few actually, say that faculty own scholarly articles and books. So faculty can produce scholarly articles and books that are the product of their research. They can do it at least in part on university time. They can sit in their office laboring over that. We want them to do that, right? It's part of the criteria of tenure and promotion, articles, books, et cetera. So, and we give the authorial rights to faculty, or we either restore them based on how our policy operates, or we never take them away in the first place. We explicitly carve that out. This is then where institutions tend to diverge a little bit. Some institutions, my own included, do assert an ownership right at the institutional level to course materials, just regular old course materials. It doesn't mean that we would say to Professor X who goes to Harvard or Berkeley, because they get fed up with my institution, you can't take your syllabus and your lecture notes with you. But we would at least assert a right to hold on to that content at our own institution. And in fact, from a technical perspective, my policy says we own those goods. Other institutional IP policies tend to afford a broader swath of rights. So some institutions say faculty own all typical faculty outputs, whether it's course materials, books, or articles. But all institutions put a stopgap when it comes to the creation of intellectual property artifacts that employ significant university resources. Where you're getting a ton of support and investment from the university asserts an ownership right. And this comes in part out of patent law areas where faculty and where institutions need to have strong and clear rights to be able to disseminate IP in a patent licensing process and get royalties back, both for the inventors and for the institution. And since distance and online education courses almost invariably involve a ton of investment, one average I've heard is that the average massive open online course right now is costing institutions $100,000 to $200,000 per course to produce. When you're talking about video recording, addressing all the rights issues, support from grad students and others, that's a very significant institutional investment. And institutions, under their universal policies around this, really do own the IP rights, or at least have a claim to them which may be shared with the faculty. So the concept that participation in these projects is robbing faculty of rights is one that I remain puzzled by. But I think you're going to be hearing more about that, and I think some of where that's coming from is really a related interest, which is a perfectly understandable concern about displacement. So the issue around academic prerogatives to choose and create courses, the concern about displacement of teaching opportunities, those are realities. We're in a very disruptive space right now in higher education. And so those concerns are clearly being brought to bear around this issue. Regardless of how all this is settled out, as I said, platform providers want clear rights, because when an institution signs up and delivers a course to a platform provider for MOOCs, the platform provider wants to know that the rights are cleared and the rights are okay. Accessibility, a huge issue and a growing one, and one where the Department of Justice and the Office of Civil Rights are really slamming us, I think, probably for some good reasons, around accessibility of new technologies and new content opportunities. We all need to expect that any form of licensing, whether we're securing content from a publisher for journal access through libraries, or whether we are delivering content online, is going to be subject to ever more rigorous accessibility expectations under the ADA and under Section 504. So institutions that receive federal funds, which is, i.e., all of us, absolutely have to think about these issues. And we're being used, quite frankly, by advocacy groups to be the tail that wags the content producing and technology dogs. So under the ADA, the Department of Justice cannot tell, let's say, Google or Elsevier, thy content must be accessible. But they can tell institution X, Y, and Z that if we license content that isn't accessible, we're out of compliance. And so there's an explicit strategy to ensure that higher ed is fully aware of our obligation so that we push technology providers and content creators to render the content accessible and compliant. That's another sort of horizon issue I wanted to flag. It's coming up in the context of MOOCs, but it goes far beyond MOOCs. Okay, now let's downshift to a different gear. I'm really going to move away. We did a little bit here on ADA. Talk for a few minutes about privacy and data use issues, and then I'll get off and we can get into hopefully a great conversation. So what is it that's really happening first, let's say, in the MOOC space? Well, it's been pretty important to the for-profit Coursera to have in their terms of use one of those many long unread 17-page documents that we all click through and don't read, to say that, hey, you're not our student. I mean, we talk about students taking open online courses, but Coursera, for example, says you're not our student, and we're not subject to the Family Education Rights and Privacy Act, FERPA, which drives an awful lot of compliance efforts at institutions of higher education. So you're not our student, and because of that, institutions who are working with an entity like Coursera, and there's lots of other companies out there, are also wanting to be very, very careful, because we don't want to be in a position where it looks like we're enabling a formal student relationship with the institution that would give rise to rights and responsibilities, not only under FERPA, but around accreditation and all kinds of other compliance environments that would put the institution in a very, very bad place with respect to its delivery of content. So the paradigm is, we're giving you content, we're not enrolling students at the institution. So, but here's where things can get very interesting. So anyone here currently at an institution where you have created courses and uploaded them, where your faculty are flipping the courses? Okay, so me too. And one of the things that I realized kind of late in the game was that we had faculty who had created great courses, and they really wanted to flip the classroom and experiment with that model, which is a very, very interesting thing, one of the important drivers of this experiment with MOOCs. But they were having students just enroll with provider X in order to take the course at the institution. That brings FERPA right back into the picture. Because if the students in enrolling for that course have got to waive their FERPA rights and agree to have their data commercially used, then actually I forced a student at my institution to waive their privacy rights in order to take a course at my institution. And it's not just some participant non-student out there in the universe who's agreeing to that trade in exchange for free access to education. It's my institution. It's something to think about. You want to make sure that that's not actually happening and that students have a legitimate choice around privacy waivers. The issues around privacy and compliance are, by the way, going to be ever broader, because the EU has an even more rigorous structure around privacy than the United States does. And I think we can expect open online course providers to be grappling, as we see Google, for example, constantly getting sued in European countries around privacy practices. This stuff's going to be part of the online space as well. And this leads me to a final couple of slides, which is, and this isn't really just about MOOC providers. The EULA, the online license, the end user license that is getting thrown in front of us every time our browsers touch the web, is actually a really important thing for us to care about. And I think it's something pretty important for librarians to care about increasingly. And I know how ubiquitous this is, and I know how hard it is. Every single person in this room who signed up for internet access clicked right past a EULA. And you don't know what that said. You probably agreed to indemnify some company wherever the service is from. You probably agreed to be sued in whatever home state jurisdiction they have. You might have agreed to share data in ways that would not be very appropriate from the perspective of your institution's policies. You just don't know because nobody reads them. And I'm here to say that when we're employing cloud products that involve a faculty or student's browser touching a web space, we actually should care about those issues. we should care about them a lot. Because fundamental issues, I think, of privacy, of IP ownership, and really of the use and access to data are implicated there. And when you start to read them, you find some very tricky and unpleasant things. For example, cloud products that are being tested by faculty in the classroom to measure learning analytics, which is one of those hot new terms. And you read through the license and realize that your faculty and your students have agreed that all of the IP that's created in that course testing space has been also given non-exclusively to the host and can be used by that company and reused by that company. And when the license does not comply with FERPA in the first place, and so your students in taking your class are having to agree to these kinds of terms, that's an issue of concern, at least to me. And I think it's the kind of issue that is also of concern to libraries. New copyright strategies of platform providers, whether they're MOOCs or others, also bring us back into this cycle, which is that platform providers are trying to do deals with publishers and content owners that are perfectly reasonable in their intentions. But if you're an institution and you've launched a course, and the course is being linked through content deals to publisher opportunities, you're not a party to that agreement. And if the platform provider is giving away the farm around privacy and IP ownership rights, and your faculty aren't reading this, and you're not interpreting it, and you're not realizing that by agreeing to utilize certain content or certain textbooks as part of a course, anyone who enrolls in the course is going to be dragged into a space, again, that has privacy or IP ownership and data rights implications. I think that isn't good stewardship. Cloud companies in general are seeing this space as really, really, opportunity rich. And frankly, they're counting on something that is true, which is that we can't all read these licenses. But when it comes to institutional programs, I mean, I have two grown-up kids now, and I know that they have very little of the sense of privacy that I might have as an old person. They throw their lives up on Facebook and they Twitter, and they really don't care very much about these issues. And that's fine in the private and personal space of all of us. But when it comes to the stewardship I think we have as institutions and libraries towards our students and faculty, I think we need to up the ante in our game a little bit. Here is, for example, something that just hit me in the last 2 weeks, which was in the middle of a negotiation I'm handling for many, many, many institutions in my state. It's a very, very big deal for a content license. And all of a sudden pops up, this is a deal we've historically done only every 5 years or so. So I'm going through the new license, and I realized that, the hard-won compromise that library had for many, many years around usage statistics and sort of that balance of patron privacy and library needs and publisher legitimate needs had suddenly been tilted by a new little clause in the license that says, first of all, said that all privacy was going to be safeguarded except as described in the license itself, which was usage statistics based, or as described in the online privacy policy. And what's the online privacy policy say? Basically, we can change our policy whenever we feel like it, which is what we all know happens with online policies. And I strongly objected to this. I mean, this is not a situation where, frankly, we should have a EULA or an online license. We have faculty and students reading articles off this database. They're not uploading to the database. They're simply reading content that we are buying at enormous expense. And I don't think their privacy rights ought to be breached when we're paying millions of dollars a year to deliver content to them. You need to watch out for these things because if you don't, you're basically setting up a dynamic where the library license resources have become another tool to harvest data in ways that you may not think are appropriate. So I'm really happy that we already got an introduction to the wonderful Woody Allen, because I'm ending with Woody Allen here. Just because you're paranoid doesn't mean they're not out to get you. Now, lest you think that I've jumped off the deep end as a lawyer for my institution, all of these things are appropriately balanced. And we're living in a dynamic world of new technology. Data analytics are here to stay. And I'm not someone who's objecting to content owners having opportunities to interact with institutions around data sharing and analysis. That's going to happen. The issue is whether it's happening in a place where the fulcrum of sort of ethics and of stewardship is reasonable, and where we're paying attention enough to these issues to not frankly get dragged right off the boat into the deep end of the sea without knowing what's happening. So my admonition here is that we need to sort of be alert to this. We need to not check our skepticism at the door. We don't want to be so excited about winning these wonderful copyright battles in federal courts, which has been an increasing trend, that we lose our critical judgment around other things that could be happening, that could be undermining some of those victories at the very same moment. So thanks so much.
Is Anthony Watkinson here? No. He's usually, as you know, at the close of every plenary session, our kind of question man and disciplinarian. And I was counting on him for that. But I think the four of us can well handle discussion with the floor. So with all the wonderful ideas we've heard, the provocative thoughts, thank you, Georgia, for that in-depth look at transformative fair use and when it might or might not be. Do we have any comments, questions from the audience? And if so, come to a microphone and tell us who you are, and let's get started. In the back.
Hello, I'm Andrea Schulman from the Harvard Business School. I've been recently told by an information provider that they could not give us data about our exceeding our download capability because of privacy issues. And I'd like your opinion about whether that is a valid justification. Thank you.
I don't think so. I think it's a question of honestly missing the boat, which I've done many times, true confessions, in your licensing arrangement to make sure you had access to de-identified or anonymized data appropriately. I mean, yeah, it would be inappropriate for the provider to be giving you the name, rank, and serial number of the individual end users who downloaded that data, but to have aggregate data or de-identified data is not a privacy violation, in my opinion. So. And actually, it's something to really think about as well, which is as much as I have some concerns about commercial entities getting access to our community's data, if you're licensing and setting up a program, there's enormous research potential in this. Not dissimilar to the issue that Georgia was mentioning with HathiTrust of sort of analytics and data analysis. It is a huge new area of research. And so you want to have access to the data from your institution or your publication. There's a treasure trove of information there.
Ben Wagner from University of Buffalo. You described not simply caveats in terms of online courses, but like a whole host of landmines. And I'm wondering how, all you need is a few cases where people get burned, and won't these massively online courses, especially in terms of international law, have to be absolutely plain vanilla?
Well, I think because we're focusing on the law here that, we really talked about fair use more than anything else, but my advice to the faculty at the University of Texas in creating courses is to, as much as possible, rely on open access materials, Creative Commons licenses, things where the owners have already indicated that they want to share their works, they want us to use them, and they want us to create new works with them. So that's the direction that we're going. We try not to have to clear rights if at all possible, and we reserve that for a limited number of images and other materials, and then we rely on fair use when we can. So in that sphere, I don't think we're headed for a disaster at all. I think we're headed for a much more open usable content world than we have today. And MOOCs are actually on the forefront of pushing the viability of that effort.
I very much agree with Georgia when it comes to copyright issues in the online space, which I think are evolving progressively and with great passion and interest. I have to validate, though, your statement when it comes to the online space generally. Actually, I just came here from a week in Washington, D.C., at a conference of higher ed lawyers, and session after session explored the almost crazy compliance environment around online ed, because it gets into many, many areas that, I mean, I kind of pushed the envelope here today to talk a little bit about privacy and FERPA kinds of issues. On one of the slides, I have a list. I mean, there's state authorization, Title IV. This is a heavily, heavily regulated environment. And people are concerned about sort of navigating those waters appropriately, and it's very complicated.
Well, a few of us in the room were in Kevin's session on Wednesday, and the thing that struck me most, and I guess it goes back to the copyright thing, he said one of the key effects of MOOCs from where he sits at Duke University is that it is pushing educators more and more to open information. Mm-hmm. And the less the information is open, the less it is going to be utilized.
Mm-hmm.
Yeah. John Dove from Cruder Reference. I just have a couple of questions. This is not an area that I know well, but you've definitely brought up some interesting areas that we need to have opinions on. So one is it crystal clear that there's a safe harbor, that if somebody, from some MOOCs that I have taken, people have had links to say, all right, go to this link, to this YouTube video, or to go to this place. Is if you just reveal a link, is there a completely safe harbor with regard to any copyright infringement?
I think so.
Good, all right, so my next question was...
Georgia?
No, I agree. Links, no one has a right to control links. That's not part of the Copyright Act, you know.
Great, so so indeed, a lot of MOOC content is actually done exactly that way. So
That's one of the things we encourage too, is linking out. Even though it might not be there someday, it's like you can't let that stop you from utilizing stuff that's out there and that people have already agreed to make freely available.
Right, so Thursday I did a little Pechakucha and had some images from a YouTube video. So if I've used that in a presentation, if I violated some copyright, I referred to the TED Talk and I said, boy, this is on YouTube and here's an example. Is that perfectly okay, yeah?
There's an issue with YouTube if you want to pop their video out other than embedding it. Do you know what I'm talking about?
Yeah.
Well, in this case, I just showed an image from it.
No, that's probably okay. That's a fair use. But using YouTube videos, there's the content owners saying, you know, I want this out, I want the world to see it, and you link to it, no problem. If you want to take it out and put it on your server because you think someday it might not be there, you need to limit your use of YouTube videos to ones that have been that have been licensed with Creative Commons licenses. Because YouTube has a special video editor that it allows users to use to pop the videos out if the owner of the content has indicated that he or she wants people to be able to Creatively Commons use it.
Yeah. So there's an embeddable player icon on YouTube videos, and so if you see that, that's an indication that the content owner who's uploaded the video has authorized your download of the video. So as with everything else out on the web, this is a mistake that, you know, I deal with in my copyright workshops on campus. People think if it's up there on the web, I must have permission to do whatever I want with it. And of course, if it's up there on the web, it means that you have a right to link to it. It's viewable from my browser, my eyeball, to the web. But what I can do with it afterwards is a subject of the rights statement or assertion of the person who put it up there. Just because it's available doesn't mean that I can use it for whatever I might want to use it for.
Bob Holly, Wayne State University. I had a student who asked the same question about privacy. So that if in a MOOC or on a library website, you're presenting access to a commercial site that doesn't have privacy, I first of all don't know if it's technically possible either in the library or as a proxy server to connect it with the individual. But if it is this a privacy issue? Should we warn the user that's clicking on Google Scholar that it does not have the same privacy rules as they expect from library materials?
Well, I was just going to say, that was real common about a decade ago to provide those statements. But I think today we really expect that people know that. That if you click on Google, you know, you're not in our little protected sphere anymore. What do you think?
Yeah, I agree. What I think I'm feeling ever more passionate about is, okay, I keep on using this analogy of the ham omelet, okay? The pig is committed. The chickens are involved. And if you're the pig, if we are affirmatively buying, licensing the content, enrolling students as part of a course in the access to an interaction with a set of services or content, then we have an opportunity to use the leverage, the moral values, and the legal requirements that we are guided by to ensure a reasonable framework with that content provider. And that's different than having broad links to a web environment that's kind of Wild West and just out there. And I think I'm with Georgia that when people are interacting with the web, they are accepting a set of, even if unread, terms of engagement that do not involve a whole lot of privacy. But if I'm saying I've spent $5 million to license library materials, and this is our user community and the access that we're providing as the library, I want that license to be clean around those concepts.
One of the questions that we asked Kevin on Wednesday was, is it possible for libraries in their e-resource licenses to provide language for MOOCs? Is that reasonable? Is it going to work? And he said, no. I then went on to ask him, I had seen something in the Chronicle or somewhere about SPOC's small private online courses. Harvard is going to do one of these for about 400 or 500 students. So the question was, at what point do you actually have a hope of licensing for these kind of wider courses? And of course, once you get into all these gray areas, it becomes case by case, I guess. So there's really not, I went away from that session thinking that there wasn't too much librarians could do in the licensing sphere about MOOCs. There's a lot of things we could do to work with our faculty, to help them, identify resources that are open or other kinds of things, but not really in the licensing space. Is that kind of a fair takeaway?
I'll tell you our experience at the University of Texas with our MOOCs that we've run so far. We asked a commercial organization to help us reach out to publishers to get permission for a very tiny set of materials that our faculty really wanted the students to have access to. These are print materials. And even this professional organization, which threw a lot of time and money at the project for us, was ultimately unsuccessful in most respects. Publishers just aren't ready to do this. They view it as, they still think in terms of wanting to charge a per person use, and it just doesn't work, it doesn't scale. But will they be there someday? Absolutely, but I'm not holding my breath waiting for that.
I think it's a really great question. I agree that libraries, especially individual libraries, are just very unlikely to be successful with a broad swath attempt to license rights for use in faculty MOOCs from any publisher. But individuals have a lot of individual power. So I've had some experience where the faculty author of a book where the author wanted to harvest image and other content from the text to populate a MOOC with was met with very friendly response from the publisher, who was delighted to have the book recommended for purchase in the course as the sort of quid pro quo to a pretty liberal use of images, for example. And that actually has happened for both authors and for non-authors who simply found a textbook they thought was fantastic and were able to work out an agreement with the publisher to have just a recommended link, not any required purchase, and then very liberal image use rights. So I think that's an issue. I can see this on the horizon for all of us who are advocates for authors working affirmatively with publishers around OA rights or other kinds of rights to say, hey, if I'm signing away my rights to publisher X, I want to be able to use content in reasonable increment amounts in online teaching, for example. So I can see that as a horizon of individual one-off opportunity. Ann.
Well, this kind of reminds me of the efforts a lot of us have made to get access for our alumni to electronic resources. And I was trying to think, some of this has happened, and maybe more will happen, I don't know. But I think one of the requirements was, obviously interest on the part of the institutions, but also venturesome publishers who said, well, let me try that. Let me try that in a pilot, and let me see what happens to use, and let me see what happens to revenue. I don't know where JSTOR is with this today, but they, approached us and said, would you like to be part of a pilot group? And there was a very small incremental fee. I think EBSCO has some of these services. So I think maybe what we're looking for now is, and for those of you who are publishers and information providers, is folks in this space who are interested in kind of stepping up and saying, let's try something together and, learn from that. And it may well lead to opening up of services that today we think are just not possible.
Yeah, I would be derelict if I didn't mention that Coursera has been working with some publishers, at least, and I think edX also, actually, to see whether light or slim versions of textbooks could be made available as a pilot, as a beta experiment on both sides, for use in some courses. And I think that's a very interesting thing. The admonition I would pass on as someone, again, who cares a lot about privacy is, what's that going to mean? What will the students or the participants who get those textbooks be assigning away as part of that deal? And we want to make sure that's a reasonable balance of rights and responsibilities on both sides. And of course, if you have a faculty member who's developed $100,000 or $150,000 series of lectures at the institution's expense that are tethered to that particular deal as far as content rights, and you want to move your course somewhere else, you just want to stream it for free from your website because you just think it's a public good, you may find that you've got to go back in and reshoot the entire course if too much image content is linked to that particular business deal. So all things to think about pragmatically.
Well, we've reached the end of our time slot, so I want to thank our speakers, particularly Bruce, for his excellent step in, and we will see you next year. Bye-bye.